think is a sham, a dog that didn't bark, but about which I'm not certain because I'm not a criminal lawyer. I can talk to you about constitutional law and things like that, but I really don't know New York law, and I've read this and I cannot figure it out. So thank you, Andrew McCarthy. Your day must be packed, friend. Welcome.
Any day I start it by talking to you, Hugh, is a good day. And what we actually need here is a constitutional lawyer, because the fundamental flaw with this indictment is that it's not an indictment.
Thank you. I'm trying not to get over my skis, and I don't know New York law, and I've done exactly one criminal prosecution defense in my life. So I just read it and read it. I kept looking. What's the felony? And Andrew, walk us through what you see and what you don't see, and why you conclude that it's unconstitutional, because a defendant can't defend himself if he doesn't know what he's charged with.
Yeah, let me start with that, but don't let me forget to get to another point, which is that it's incoherent. But let's start with why it fails as an indictment, which is a constitutional question. It's not the esoterica of New York law is beside the point for this. In the United States, under our constitutional system, an indictment serves two purposes. One, it has to put the defendant on notice of exactly what's charged so that he can prepare his defense. And two, it gives him double jeopardy protection. That is, by stating the offense that's charged, the indictment stands as a defense if the person is ever charged again by the same prosecutor, so that he can say, no, I've been charged with that already. This indictment fails as an indictment because it does not tell Trump what the crime is. The allegation is that Trump falsified business records with fraudulent intent in order to conceal the commission of another crime. But nowhere in the indictment does Alvin Bragg, the district attorney, state what the other crime is. Therefore, Trump is not on notice of what he's charged with. And it is suggestive of an even deeper constitutional violation, which is that you are guaranteed under the Fifth Amendment a right to be indicted by a grand jury. The district attorney is the legal advisor of the grand jury. In advising the grand jury to return an indictment, which means they have to find probable cause of every essential element of the crime charged, the district attorney has to instruct the jury on what the law is pertaining to all of the essential elements of these crimes. He may not have told Trump what the other crime is. He may not have told us what the other crime is, but if he didn't tell the grand jury what the other crime is, then they can't have found probable cause, which again means that the indictment fails as an indictment. It isn't an indictment because it's not reflective of a probable cause finding by the grand jury, and it doesn't state a crime, so it fails just fundamentally as an indictment.
All right, that's a constitutional problem. I'm going to come back to that, but I want to remind you about the incoherence, because now I'm feeling better. I could not make heads or tails out of it. I mean, I know the fact pattern. I know what they're alleging on the fact pattern, but I could not find a legal theory as to why it was brought forward. It's incoherent. You use that word. Would you expand on that?
Yes. The bottom line theory that Bragg has is that Donald Trump stole the 2016 election by fraud. Even if we indulge that for a moment, the problem is the first crime that he charges occurred on February 14th, 2017. The last crime occurs on December 5th, 2017. Are we seeing a problem here? The election was on November 8th, 2016. No matter what you do, you cannot defraud something that happened in 2016 by actions that happened in 2017. It's not possible. So what is Bragg actually doing here? He's trying to criminalize. We've talked a lot, Hugh, about, is he criminalizing federal election law, and does he have authority to do that? And is he trying to apply state election laws? More fundamentally, what he's trying to do here is criminalize non-disclosure agreements. The only activity that happened in this case that Bragg alleges that predated the 2016 election are the non-disclosure agreements. They're completely legal. So the action in the case, which he says is driven by Trump's fraud in connection with the 2016 election doesn't happen until 2017, which is how the NDAs are booked. No matter what you think about that, it can't possibly have had an impact on the 2016 election. Moreover, even if Bragg was correct that these were in-kind campaign contributions that had to be disclosed, let's indulge that fiction for a second. Let's even say Donald Trump recognized that these payoffs to various people for their silence should be deemed to be in-kind donations to a campaign, and they should be reported to the FEC. Under federal law, because these happened so late in the 2016 cycle, he wouldn't have had to report them until months into 2017. So there's no way they would ever have been disclosed prior to the election, and they can't have had any impact on the election.
So people who are using terms like threadbare and weak sauce, or insulting threadbare and weak sauce, I don't think there's anything there, Andrew. And Senator Cotton just used the term star chamber. Now I want to go back to the fundamental problem. In the United States, not only is there a presumption of innocence, there is an obligation to let a defendant know what they're being charged with, so that motions can be brought, whether it's a habeas petition, whether it's a dismissal motion. I don't know how the lawyers on Team Trump bring a motion to dismiss if they don't know what the charge is.
Yeah, well, that's the motion to dismiss, right? The indictment fails as an indictment. The indictment fails to state a crime. And I don't know what the motion schedule is that the judge set yesterday. I'm sure it's been reported in places. We didn't have it in real time as we were covering it yesterday. But I'd be under the judge's toes today seeking to get the indictment dismissed because it doesn't state a claim. And I've heard a lot of stuff, Hugh, in the media about, there'll be a bill of particulars and he'll lay all that out. No. You don't get to do it. A bill of particulars does have the function of fleshing out things that a defendant rationally needs in order to prepare his defense. But a prosecutor doesn't get to stamp the word crime on a piece of paper and then say details to follow. You have to put the essential elements of the crime in the indictment, because if you don't, you haven't given the defendant notice of the crime. And secondly, if you don't, it must mean that you didn't instruct the grand jury on what was being charged. And if you didn't, then how can the grand jury have found probable cause, which is what they have to do to indict?
I'm going to come back to that. I'm also going to ask you a question before I forget it. The indictment was sealed. I found that odd on Friday, even more weird on Monday and Tuesday, and now I know why he did it. He wanted to evade the searing criticism of his, quote, theory and the Grand Canyon-sized hole in the indictment of failure to charge a felony. Do you have any idea how he can defend a sealed indictment for 3 days? He did it to defend himself, is what I think.
Well, what I'm told you, my practice of criminal law in Manhattan was in federal court.
Yeah.
I was a federal prosecutor. I wasn't a state prosecutor. So I thought that was peculiar, too, because in our office, the only time you sealed an indictment was if the defendant was at large and we needed to arrest him. And it was the kind of defendant who you would think would flee if he found out that there were charges. So you seal the indictment, you get an arrest warrant, and as soon as the person's in custody, then you unseal it, right? What I'm told is that the practice in Manhattan is different, that when they proceed with a case by indictment as opposed to when you proceed with a case by a sworn police complaint, when you actually go to the grand jury and get an indictment, I'm told that their practice is that the indictment stays under seal until the defendant is arraigned, and it is given to the defense counsel first at that point. Now, I'm told that's the way they do it. If that's the way they do it, then he was simply, following the practice.
Then I'll withdraw my objection. I mean, if that's New York trial practice, I'm not a New York lawyer. All right, now, Andrew, let's go back to your prosecutorial experience, though. When you had a weak case in the Southern District of New York, but you really hated the defendant, how would you kick it around the office? When you got a bad guy, but you ain't got a case, what did you talk about?
Well, I think here's a good example. I had this happened a few times, and more when I was a boss. I mean, when I was a young lawyer, the good thing about the office, and this was also the case with the Manhattan DA's office in the time of Bob Morgenthau, who was the legendary district attorney there for 34 years. When you wanted to do something wild and crazy, Hugh, the leadership was like the adult supervision to make sure that kind of stuff didn't get done. Here it looks like the leadership is the problem. But like, for example, I would have somebody, a young lawyer, come into my office and say, I want to charge somebody with a push-in robbery. And I would say, but push-in robberies aren't federal crimes. And, you know, in the Southern District of New York, the ethos of the office is you're supposed to be creative, right? Pushing the envelope all the time, which is a kind of a dangerous thing. And, you know, the young lawyer would say to me, but this is interstate commerce because we don't print money in New York. So the money had to have moved in interstate commerce at once. So what I think generally happens is if you have a case like that where you're pushing a legal envelope, what you kick around is this a precedent that we can live with and that we can defend in the Second Circuit, even if we can run it past a judge, which in the Southern District, we have very good judges. You probably wouldn't be able to get something like that past a judge.
Okay, and when you had a good guy being charged, because I'm not putting Trump on the good guy, bad guy spectrum. I'm just talking about your experience. When you have a bad guy you want to get, you still have to be careful. When you have a good guy that you regret going to get, how do you adjust the process there?
I think that, you know, thinking back, I'm glad you asked me this because I wouldn't have thought about it this way. But I think, you know, back in the old days, even though you would think about the defendants as bad guys, in order to sort of make sure that you didn't do something stupid, you thought more about their lawyers than you thought about them.
Oh.
You know, if I had a mafia guy who was a really bad guy, I wouldn't get carried away because I would imagine if I do X, Y, or Z thing, what is this very, very good defense lawyer going to do to my case in front of the jury? And that has a very sobering effect. And I think part of the reason we probably think that way, Hugh, is some of the best defense lawyers in New York are veterans of the U.S. Attorney's Office in Manhattan. So you would think about your former colleagues dismantling your case, and that actually has a pretty good effect on policing yourself.
Now, I don't think Alvin Bragg is capable of embarrassment, Andrew McCarthy, because he's in Manhattan and he's popularly elected. The judge in this case I am unfamiliar with. I try to always give the benefit of the doubt to the judge, but he has to have a motion brought to it. Is there any way to get this out of an elected state court judge's office and out of Manhattan into a federal court, to your knowledge?
No. I mean, it's just not a federal case. In fact, part of the weakness of the case is if we could get Bragg to fess up what crime he says Trump is trying to conceal, what he seemed to be suggesting at times yesterday in his press conference was that it was federal election law, which he doesn't have jurisdiction to enforce. I would point out, you'll probably find this interesting, the statute that Bragg is using that makes falsification of business records a felony says if it's falsification of business records that is committed to conceal, and what the statute says is another crime. That's the term. I don't think that can be read as anything other than another New York crime. This is the New York Penal Code. So when it refers to a crime, it's talking about a New York crime. I don't think the New York legislature would have jurisdiction to allow the district attorney to enforce federal law, but we'll never come to that because they didn't try to do it. It was clear that what they're talking about here is a New York crime. And I think the reason that Bragg doesn't want to come out and say that Trump was concealing a violation of federal election laws, aside from the fact that he wasn't, is that it would be too obvious that Bragg just simply doesn't have jurisdiction to enforce that.
Okay, indulge me, Andy. The 14th Amendment prohibits states from interfering with the due process of law. I think the fundamental nature in history and tradition in the United States is that defendants are fully informed of what they are charged with so they can prepare a defense. Is there no way you can think of for Trump's lawyers to put that in front of a federal judge in the Southern District of New York?
I think what any federal judge would say, Hugh, is that they're going to stay their hand until the state process runs its course. I don't think that a federal court would pretermit this. You would sit back and let the state court do the right thing. I mean, the judge who has this case should do the right thing here and throw the case out. And I don't know a lot about this judge either. You know, Trump has had a lot of unkind things to say about him. I'm like you. I'm willing to watch and wait. But I will say this. The DA put a lot of pressure on him, and there's been other pressure on him to gag Trump yesterday, to issue a gag order, and he refused to do that. And the only thing he said to Trump, which I thought was pretty benign, was don't incite violence, which is like me telling you don't murder anyone this week.
Right.
You know?
Well, in the Post today, you were talking about schedule. The Post reported this. Trump is not expected to appear in court again until at least December, but his attorneys will file what is likely to be a lengthy set of motions in August, and prosecutors must respond in writing 6 weeks later. The judge would then potentially order hearings and set a trial date. I think that is a crime against the people of the United States. I just can't tell people how angry this makes me that we're sent into legal limbo without a theory of the case that the Trump lawyers can act on expeditiously because he's holding the American political process hostage, Andrew.
Yeah, but I don't think anything about that schedule stops a lawyer for Trump from marching into court today and asking for immediate relief, saying that, you know, look, we're behind the eight ball here because they didn't even hand us this indictment until 2:30 yesterday afternoon. So now that we've had a night to read it, we realize it doesn't state a crime. And we gave them the benefit of the doubt because we hadn't had a chance to study it. But now that we have, it doesn't state a crime. We can't have a situation and they can make this a constitutional argument and try to frame it that way, that this is an intrusion of state law enforcement into the federal electoral process, and it shouldn't be allowed to happen unless there is a serious crime that is backed by at least an indication that the prosecutor has convincing evidence. Here, they failed even to state a crime. Forget about the fact that their evidence appears to be flimsy. And I think if I were they, I would try to get under the judge's toes this morning.
I agree with that, but I think I might also try to go to a federal just for the framing of this, to make sure the public understands he hasn't been charged with a felony yet, and all the mumbo jumbo at the press conference is not legally of any significance. I think it's a violation of the 14th Amendment, but I haven't taught criminal procedure ever, much less practiced in the federal courts. I appeared in drug court once with the son of a friend. That's my criminal experience, all said and done, Toto. So I have no idea.
Yeah, I think we're just talking tactics here more than strategy. I don't disagree with you, but I think if I'm the lawyer who thinks I may eventually have to try the case in front of this judge, I want to give him the chance to do the right thing before I. Oh,
that's a smart observation. So, Andrew, I want to wrap up this way. I have gone looking. The dog that didn't bark is a liberal defending and applauding Alvin Bragg. Someone with credentials. And there are lots of them. Neil Katyal. I mean, there are lots of people who are talking heads on, and I don't count Andrew Weissman. Is there anyone, have you seen anybody applauding Alvin Bragg's approach and saying this is good, solid lawyering and Trump's in trouble?
No, I think that, there are lawyers who I like and respect on the other side. Preet Bharara, who, I knew in the office, and Neil, who are very fine lawyers and who are, as I understand it, they're friendly with Bragg. And my understanding, Hugh, is that what they cautioned everyone was to keep their powder dry because we hadn't seen the indictment yet. And even though I thought there was enough reporting out there and that it was reliable enough that we could pretty much understand what was in the indictment, and that turned out to be the case, I didn't object to being admonished that, you should at least see it before you go, to DEFCON, whatever. But I haven't heard anybody come out and try to defend this.
Yeah, it's crickets. I just want to know if you would validate that. My last question. Andrew Weissman was part of Robert Mueller's team. Robert Mueller's team looked high and low in every shelf. They took every book off of every library in the country looking for something to get Trump with. Would they have seen this material and would they have passed on it?
Yeah, I don't think there's any reason to think otherwise, Hugh, because let's remember what the history was here. The Southern District of New York, my old office, which is famously aggressive, and which, because the New York State Constitution follows a principle called equitable due process. Equitable double jeopardy, which means if somebody else indicts on anything that is part of the criminal transaction that's alleged, New York can't charge. So we always had a trump card whenever we had a turf battle with the Manhattan DA's office, which happened frequently. We could always jeopardy them out by charging, which is not with most states. It's dual sovereignty, and one can't jeopardy out the other. So the Southern District had this case, and it didn't have to give it to the Manhattan DA's office. And when it has an attractive case that it's trying to make, it never gives the case to the state. And here they had Michael Cohen. They actually got him to plead guilty to 2 campaign finance offenses that I don't think he was actually guilty of. And the only reason he pled to them was because his guidelines were so high on the fraud counts he was looking at that they didn't make a difference to him time-wise. But he was trying to sell himself to the Southern District as a potential cooperator, and they had him implicate Trump when he pled guilty, which is a very unusual thing for prosecutors to do. But after taking a long look at this, they dropped the case because they thought they didn't have it. And then Cy Vance dropped the case. And then Bragg himself dropped the case. So everybody has known for a long time that this case is awful. Even Mark Pomerantz, who writes this book about how Bragg should have indicted Trump, what he's talking about is Trump's history of financial dealings, which actually what Mark is talking about in his book is what Tish James ended up putting in her civil complaint. But all the prosecutors who looked at this said that there's no proof beyond a reasonable doubt of a crime. But I think Bragg got mowed into this.
Oh, he did. That's clear. But the Southern District of New York passing is one thing. I'm just wondering if the special counsel, we have a minute, if Robert Mueller's team would have seen these facts, because I believe they would have been in the Mueller report if they thought them in any way relevant to smearing Trump, because that was what Volume 2 was all about.
Michael Cohen cooperated with Mueller and pled guilty in part of the Russia-Gate stuff to committing perjury in front of Congress. So he gave them the whole Stormy thing. There was no crime there.
And they passed too. So it's not just the Southern District, it's also the special counsel.
Yes, and he had jurisdiction, as we know. He had jurisdiction. Any crime he found on Trump during the course of his investigation, he could have charged.
Andy, thank you for making time for me this morning, friend. And I know you're going to be on.
Thanks, man.
If I were, you should just go get a cot and put it over at the Fox Green Room and lie down between appearances. Andrew C. McCarthy, follow him on Twitter. Always listen to him. He's your go-to guy because he actually is a prosecutor and knows what he's talking about, as opposed to the 99% of us lawyers who are on TV who pretend to know what we're talking about, and then as opposed to the pundits who actually have no idea what they're talking about. Stay tuned, America. I'll be back for your calls in hour 3 on today's Hugh Hewitt Show.